Elsewhere, the Independent Electoral and Boundaries Commission has been tasked to explain why it needs a clarification from the Supreme Court on the judgment that annulled the presidential elections. The Commission has filed an application seeking to understand the role of the chairman when verifying the presidential election results.
Well, the Supreme Court, however, insists that its judgment was clear, and the opposition says the IEBC is trying to appeal to the Court of Appeal decision that said results declared at constituency levels are final and cannot be altered.
The chairman then compares 34A and 34B and finds that there is the tally in 34B is different from the tally in 34A. According to the minor KI case, it says there is nothing that he can do. But according to the decision of the court, it appears to say that he is required to carry out that verification process. So that the question that we are then asking is, if at the end of the verification, it turns out that there is a discrepancy between those two, what is he then required to do? So that the omission that we are saying was there is that when the court said carry out the verification, it didn't complete that direction by then saying what happens in the event of a discrepancy. And that is why we are back before your lordships.
So where is the problem between minor KI and what we said? Can you put it in a language that we can understand then? Because up till now, I honestly do not know where the problem is. Minor KI said, don't touch, don't move a comma, don't do anything. Did we say touch, move a comma, change figures? Did we say that in our judgment?
Yes.
Where is the problem? No, I don't remember saying that. And I know I participated in that judgment.
Yes.
Where is the problem? What is it that we are required to clarify?
Why does this court want the National Returning Officer to verify 34As against 34B? For what reason? Number two, what is this court suggesting that the National Returning Officer should do if there is any discrepancy between the contents of 34As and 34Bs? That's the clarification we are seeking for you.
The Court of Appeal has the power to interpret its own decisions, and there is nothing that could have prevented either the parties going there earlier or even later to seek that. Those are some of the procedural and substantive questions that it appears that an appeal is being lodged from minor KI Court of Appeal decision 2016 through what one can politely call through the back door. A process that is basically to defeat the course of justice and raise hypothetical questions and have this court basically act as the chair of IEBC.
Having heard the second respondent on the issue he wants to raise before the court, and having also heard the other parties, we direct that the second respondent files and serves his written submissions by the end of the day today, and the other parties to file and serve theirs by the end of the day tomorrow. The submissions to be limited to 5 pages of at least font 12, 1.5 spacing. The matter to be heard on Wednesday, the 11th October at 10 a.m.